Ma'am, shall we start? Am I
Yeah,
audible,
sir.
ma'am?
Yes, yes, yes.
Okay, ma'am. A very good afternoon, everyone. It gives me a great pleasure to welcome you all to the 10th lecture of Mission Nyayadrishti Samvad, an ambitious marathon series of 100 online lectures initiated by the Department of Law, School of Legal Studies, Central University of Karnataka. This mission was formally inaugurated on 24 September by our esteemed Vice Chancellor, Professor Battu Satyanarayan sir, and Honorable Justice H.P. Chandes sir, Judge of High Court of Karnataka. This initiative is envisioned as a step toward expanding access to legal education in alignment with Viksit Bharat 2047 and also the Sustainable Development Goals. By inviting eminent scholars from India and abroad to share their equitable education for learners across the country, it is scheduled every Friday for the next 2 or 3 years. It seeks to bridge the gap between academia and learners, fostering dialogues, critical thinking, and global exposure. Today, we are truly privileged to begin this journey with Lecture 10, and I am delighted to introduce our distinguished resource person, Dr. Sheena B. Nair, ma'am, Assistant Professor of Law, Wales Institute of Science, Technology, and Advanced Studies, Chennai. Dr. Sheena B. Nair, ma'am, has 7 years of practical experience in lower courts and high courts in Chennai and Kerala, and also 8 years of work experience as an academician. She has completed her PhD in administrative law on the topic Duty to Act Judicially and Analysis of Administrative Justice in India from Vistas, Chennai. Her teaching interests are constitutional law, family law, and administrative law. She has published 2 articles in Scopus Index journals and also published 3 articles in peer-reviewed journals. She has organized for webinars and she has also presented more than 20 papers in various national and international seminars. She was also a resource person in 2 national seminars organized by the Schools of Legal Studies, CUS at Kerala, and a speaker in a national seminar organized by Villupura Government Law College, Tamil Nadu. We are deeply honored to have such a distinguished scholar among us today. On behalf of everyone present, ma'am, and looking, thank you so much, ma'am. Thank you.
Good evening, everyone. Good evening to the organizers and the participants here. I'm very grateful for inviting me as a resource person in this 100-day lecture series. Thank you for inviting me as a resource person in this by School of Law, Central University of Karnataka. My topic is, shall I start? Hello, shall I continue?
Yes,
Hello.
ma'am. Yes, ma'am. Yes, ma'am.
Okay.
Yes, ma'am. Yes, ma'am.
First slide, please. Okay. So, first slide topic. My topic is gender pluralism in a constitutional perspective. So, yeah. Second slide.
Ma'am, you are not perfectly audible, ma'am. I think some
Yes.
network issue.
You can't hear me? Hello? Can you hear me?
Well, you're perfectly
Yes,
audible. I
ma'am.
think
Yes, ma'am. Yes, ma'am.
Saikat has some network issues from his end because his screen is also not visible. I think he got disconnected.
Okay, sir. Sir, second slide, please. Okay. So the topic is gender pluralism in a constitutional perspective. First of all, we should understand what is gender and sex. So gender is a term which refers to socially constructed roles, behaviors, expressions, and identities of girls, women, boys, men, and gender diverse person. Gender builds on biological sex, but it exaggerates biological difference and it carries biological difference into domains in which it is completely irrelevant. Whereas sex is the biological identity in which all human beings are born. It is a system of socially constructed ideas, beliefs, and associated behaviors of what is feminine or masculine within a given culture. So, second slide, please, sir. So, even if a person born as a man or woman, it is the sex cannot be changed. Sex cannot be changed, but gender can be changed. It is next is pluralism. Pluralism and gender pluralism. The pluralism is an ethic of fairness and respect. These are not only cornerstone values but also acknowledge the need to reconcile sometimes competing claims of group rights and human rights and the obligation of or choices implied. Respecting the difference depends on a capacity and willingness to acknowledge, negotiate, and accommodate alternative points of view. So pluralism means if there is any difference, you have to recognize it it is an ethic of fairness and respect. Gender pluralism means it is a recognition, acceptance, and protection of multiple gender identities beyond the traditional binary of male and female. It acknowledges that gender is diverse, fluid, and culturally constructed, and that individuals may identify in many different ways, such as transgender, intersex, non binary, gender queer, third gender, and more. It is a recent sociological theory that seeks to identify and understand all gender identities or expressions in addition to the binary male and female. It was emerged in the 2005. This theory is emerged in 2005, and it aids in identifying different gender and sex identities. Information gathered by use of this theory helps society address the needs of marginalized gender identities. So, my with related to my topic, and I have discussed that what is gender, what is sex, what is pluralism, and what is gender pluralism. Gender pluralism means identifying the a gender other than the binary, which is a male or female. Plus, next one, next slide. So, coming to the history of gender pluralism, the recognition of third gender in the Vedic period, in ancient period, then Middle Ages, and pre-constitutional, we are discussing. If you see the Vedas and Puranas and epics, we can see that the gender was mentioned. That gender diverse was mentioned in the Vedas, Puranas, and epics. The characters like a Shikanti was mentioned in a character was there in Mahabharata, and Brihanla, Arjuna's form, reflect as transgender identities. In Ramayana also, Raman has identified the third gender for, and he has got their assistance in his Manavasa time. Then Manusmriti recognized, but it restricts the rights of these people. Arthashastra respect and giving punishment for insulting this third gender. Narada Smriti recognizes the homosexual unions and women's rights. Next slide, please. In Mughal period, Hijaras held important roles like advisors, generals, and administrators. Then they were considered as guardians of harems, Mecca, Medina. They held influence and wealth. Next slide, please, sir. So during the British rule, there was a stigma introduced by the British. They have enacted Criminal Rights Act 1871. They targeted Hijras. They branded them as criminals, and imprisonment and a fine was imposed on them. And this act is, though this act was enacted before Constitution, it was repealed in 1952 only. And Indian Penal Code 1860, Section 377, it was criminalizing the unnatural of sexual of act. So British colonial rule was they were trying to criminalize the third gender. They were trying to make them as they were trying to impose punishment on them. Next, sir. So coming to the constitutional provisions for gender pluralism, the preamble, the mind of the constitution makers, it says that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. So if we see that the we means all people are involved in that. That is, whether you are a male or female or you are a transgender, we have solemnly resolved this to constitute India into a sovereign, socialist, secular, democratic and republic. And to secure all citizens. So that citizens may include all the, whether you are a male or female or transgender, equal justice, social justice, economic justice, and political justice, liberty of thought and expression, belief, faith and worship, equality of status and opportunity, and to promote among them fraternity, assuring the dignity of the individual and the unity and the integrity of nation. So the preamble itself recognizes that the people, the person who is a citizen of India, whether you are a transgender, whether you are a male or female, the Constitution guarantees justice, social justice, economic justice, political justice, liberty, equality, fraternity, everything. So next slide, please. Coming to the fundamental rights. So the fundamental rights are available to every citizen of India. I am particularly pointing some important articles. Article 14 says that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. So these two concepts, these 2 points says that equality before law. There shall not be any privileged person or class above the law. So it says that whether you are a man or woman or transgender, equality will be assured. And equal protection of laws, as we know that it permits a reasonable classification for the welfare of people. There shall be a reasonable classification among those who are unequal. Next slide, please, sir. Article 15 says that prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. So, Article 15, the state shall not discriminate against any citizen only on the ground of religion, race, caste, sex, place of birth, or any of them. So, this particularly mentions that whether you are a man or it is understood that sex means you are man or woman or transgender, and no citizen shall on the grounds of only of religion, race, caste, sex, place of birth or any of them to be subject to disability, liability or restriction or condition with regard to access to shops, public restaurants, hotels and places of public entertainment, the use of wells, tanks, bathing huts, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So, Article 15 prohibits the discrimination on the ground of sex. Next one. Article 16 says that the equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. There shall not be there's no citizen shall be on the grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible or discriminated against in respect of any employment or office under the state. So this particularly mentions that equality of opportunity shall be given to every person irrespective of religion, race, caste, sex, descent, or place of birth or residence. Next slide, please, sir. Article 19, the freedom, six types of freedom. All citizens have the right to freedom of speech and expression, freedom to assemble peaceably and without arms, freedom to form association, freedom to move freely, freedom to reside and settle in any part of the or territory of the territory of India, or freedom to practice any profession or carry or any occupation, trade, or business. So the freedom is guaranteed to the gender. This is understood from Article 19. Next slide, please. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. So the no person means that it is wide enough to accommodate citizen as well as non-citizen. So even though you are a citizen or a non-citizen, it can include any person, whether you are a non-citizen, whether you are a non-citizen, transgender person, you are also have the right to personal liberty, but there should be a procedure. If your liberty is restricted, it should be according to any procedure established by law. Next one, sir. Article 21A, right to education. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may by law determine. So we know that Right to Education Act is enacted. So it is also applicable to transgender person or third gender person or what is called the gender, the third gender person. Next, sir. Article 23 says that prohibition of traffic in human beings and forced labor. So, traffic in human beings are and a beggar or any other form of forced labor are prohibited under Article 23. So, if any transgender persons are being forced to begging or any other forms of forced labor, it is restricted under Article 23. Next slide. So, this is particularly I have mentioned, but all the fundamental rights from Article 14 to Article 32 are applicable to every transgender persons. But since they are discriminated, I have particularly mentioned Article 14, 15, Article 19, Article 21, Article 21A, right to education, then Article 23. Now, the directive principles of state policy says that the state should make a policy with regard to protection of or welfare of the transgender people. So, Article 38 focuses on reducing inequalities and securing justice. Article 39 ensures fair livelihood, equal pay, and protection against exploitation, which is crucial for transgender individuals. Article 39A, free legal aid and for addressing discrimination faced by transgender persons. Article 41 guarantees right to work and public assistance during unemployment or disability. Article 42 promotes humane working conditions. maternity relief, which should extend to fair wages and support for diverse reproductive needs for transgender individuals. We know that some transgender persons, they are, we have recent examples in Kerala, two transgender persons, they have married and they have a baby. The state should ensure maternity relief for them. Then Article 43 ensures decent working conditions and fair wage workers for all, including transgender people. Article 46 aims to protect marginalized groups, including transgender individuals from exploitation. Article 47 focuses on improving public health, nutrition, benefiting transgender individuals as well. Next, sir. But we have gender pluralism is mentioned, though it is not explicitly mentioned, but it is impliedly mentioned under the constitutional provisions under Article 14 or 15 or 19 or 21 or 23. Directive principles of state policy compels the state to make a policy for the protection of transgender people, for the welfare of transgender people. But through judicial interventions only, the gender pluralism is recognized. So one such case is that NAS Foundation versus NCT of Delhi. In that case, the right to privacy, it was challenged that we know that Section 377 of the Indian Penal Code criminalizes unnatural sex. So they have challenged the Section 377 of IPC, since they felt that the petitioners felt that Article 40, it violated Article 14, that is equal protection, because it failed the rational nexus test and created an arbitrary distinction between procreative and non-procreative sexual acts. Then right to privacy under Article 21, and it was they have argued that right to privacy was violated, and private consensual sexual conduct was should be considered as right to privacy under Article 21. Then Section 377 decriminated on the basis of sexual orientation, and it is a violation of Article 15. But in this case, since it was gone to Supreme Court and again remanded to uh, um, Delhi High Court told that Section 377 criminalizes consensual sexual acts in adults, and it is a acts of adults in private, which is violation of Article 21, 14, and 15 of the Constitution. So we can see that judicial intervention is needed to protect the constitutional rights guaranteed under the Part 3 of the Constitution. Next. But again, in Suresh Kumar Kaushal versus NAS Foundation, they have approached the Supreme Court for recriminalizing Section 377. Again, Supreme Court was recriminalized the Section 377 of IPC, and they held that it is not violation of same sex in private is not violating Article 21 of the Constitution. Then it recriminalized the Section 377. Next slide, sir. Again, in Navjot Singh Johar versus Union of India 2018 Supreme Court judgment. So after Suresh Kumar Kaushal case, the concerned person Navjot Singh Johar and the other persons agreed by that judgment. They have approached the Supreme Court for rechecking of Section 377, and the Supreme Court held that the criminalizing consensual sexual act violated several fundamental rights enshrined in the Constitution. Article 14, equality before the law. The differential application of the law infringed on the principle of equality. Then Article 15 says that discrimination on the basis of sexual orientation was inherently unjust. Article 19, restricting one's ability to express their identity was an unreasonable limit on personal freedom. Article 21, right to dignity, sexual autonomy, and privacy is intrinsic to the very notion of personal liberty. Navjot Singh Johar decriminalized the Section 377, but still it is a criminal act if bestiality is done, if sexual unnatural sex is done without consent, if unnatural sex is done on a child. But consensual sexual activities are decriminalized under Navjot law. Next, Nalsa case. It is a landmark judgment, 2014. It was this judgment has an impact on my topic that this judgment considered the person other than male and female as third gender. So the prayer was that whether a person who is born as a male with a predominantly female orientation or vice versa has the right to get himself to be recognized as a female as per his choice more. So, when such person after having undergone operational procedure changes his sex as well, whether transgender who are neither male or female have the right to be identified as a third gender. Next, sir. So, Nalsa judgment recognized the third gender under Article 14. It recognized that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. The court held the article affords protection to any person, so it includes a transgender person. Any citizen inter alia on the ground of sex equally apply to transsexual persons. According to the court, the use of the word sex in the article is not just limited to biological sex of male or female, but intended to include people who consider themselves to be neither male or female. As to the right of freedom of expression guaranteed under Article 19(1)(a), the Supreme Court ruled that it includes one's right to expression of his self-identified gender, and notwithstanding legitimate exceptions pursuant to Article 19, Clause 2 of the Constitution, that is, no restriction can be placed on one's personal appearance or choice of dressing. Next, sir. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Supreme Court interpreted that this provision broadly protects those aspects of life which go to make a man's personal life meaningful, including one's right of self-determination of the gender to which the person belongs. Accordingly, the court held that hijaras the ordinance therefore have to be considered as third gender over and above binary genders under the Constitution and law. Next. Justice K.S. Puttasamy and other versus Union of India and others, they recognized the gender recognition of gender identity. In this case, the court held that the right to self-determine one's gender identity is protected under the right to equality and the right to life and personal liberty. Article 15 and Article 21, right to life and personal liberty. Right to privacy. The judgment confirmed that privacy is fundamental right, which includes right to privacy of one's gender identity and sexual orientation. Then non-discrimination. The court's reasoning and its subsequent application in other cases have been used to argue that discrimination based on gender identity and sexual orientation is unconstitutional. So this judgment laid the groundwork for subsequent legal advancements such as the decriminalization of consensual sexual relationship in Navjot Johar case, which built upon the right to privacy and decisional autonomy established in Kutaswamy. Then protection of personal data. The court also emphasized that personal data, including one's gender identity, must be protected with adequate safeguards against misuse. Next slide, please. Supriya Chakrabarti and other versus Union of India. In this case, 2000, they have argued that non-recognition of same-sex marriages violates the right to equality, freedom of expression, and dignity. They relied on the Nalsa versus Union of India and the Navjot Singh Johar versus Union of India, which recognized the non-binary gender identities and a guarantee. But on October 17, 2023, Supreme Court five-bench judge pronounced its verdict on petition seeking marriage equality for LGBTQ persons. The bench unanimously held that there was no fundamental right to marry, and the court could not recognize LGBT persons' right to marry under Special Marriage Act, equal right to homosexual persons. But this case also mentions that if a person marries a uh, uh, trans person. Suppose a man marries a trans woman or a woman marries a trans man, they can register under Special Marriage Act. Next, sir. Again, it came for Supreme Court's consideration under review. Again, Supreme Court held that Supriya Chakrabarti's case, Supreme Court held that they cannot decide on the same-sex marriage. It is the matter of Parliament. They have to make a law in this regard. Now, Arun Kumar and others versus Inspector General of Registration and others, it is a whether the term bride are mentioned in Section 5 of Hindu Marriage Act meant only woman or included transgender person. So, two person, Arun and Srija. Srija was a trans woman, but in Hindu Marriage Act, it clearly mentions that the conditions of marriage under Section 5 is bridegroom and a bride. But the question before the court was that whether bride shall include a trans woman. The court stated that marriage solemnized between male and trans woman, both professing Hindu religion, was a valid marriage, and the court stated that transgender person has the right to decide their self-identified gender as upheld by Supreme Court in Nalsa, then Justice case, Puttaswamy case, and Navjot Singh Johar versus Union of India. Next, sir. So we have seen so far that fundamental rights are guaranteed to transgender persons, but a clear meaning or the expressive meaning of their rights are mentioned through judicial interventions. So after all these cases, Transgender Persons Protection of Rights Act has been enacted. This section 2 defines who is a transgender person. Section 3 bans discrimination in education, employment, healthcare, public services, residence and movement. Then right to pursued identity. Any transgender person who has identified his identity, he can apply for certification of identity and revise the certificate after post surgery. Then government obligation for welfare schemes, inclusion, rescue and rehabilitation is mentioned under section 8. Section 9 to 12 mentions about the non-discrimination in employment, designation of complaint officers, then right to family residence. Section 13 to 15 mentions about inclusive education, vocational training schemes, health care, etc. Section 16 to 18, National Council for Transgender Persons should be established. Then offences are mentioned under Section 19 to 20. If any transgender person is discriminated, the concerned person is liable for 2 years imprisonment and fine, and compensation provision also mentioned under this section, and inspection powers are given to concerned authorities. Next, sir. So, as per sections 21 to 24, rule making power of the government, the central government has enacted, has made rules, that is transgender persons protection of rights rules. As per this, the government of India, through the Ministry of Social Justice and Empowerment, has launched several measures to protect and empower transgender persons. The National Council for Transgender Persons, it advises on policies and monitors welfare schemes. National Portal for Transgender Persons was launched in November 25, 2020. It enables the online application for identity certificates and access to benefits. The SMILE scheme, which introduced in February 2022, which provides livelihood, skill training and shelter support through Garima Grah Centers and Ayushman Bharat TG Plus health coverage. These initiatives collectively promote inclusion, dignity, and equal opportunities for transgender citizens. In addition to that, Department of Social Justice and Empowerment has issued equal opportunities policy for transgender persons to ensure that the transgender community has equal access to employment opportunities, etc. This NALSA judgment has an impact on many cases came after that. One such case is Jacqueline Mary versus Superintendent of Police. At the Madras High Court, the petitioner was dismissed from her position as a woman police constable on a number of grounds, including the fact that she has not disclosed her transgender identity and had applied under the woman quota. The court upheld the right to self-identity, her gender, and ordered that she be reinstated. Next, sir. Shivani Bhatt versus State of Delhi and others. In this case, the light of a 19-year-old transgender person who identified as a male who was facing violence and harassment from his family in India. The court cited the NALSA judgment while ordering, and the concerned person was given police protection until he left India. Vimala Srivastava versus State of UP and others. In this case, the Allahabad High Court cited the NALSA decision more while making more general point about gender equality. NALSA decision also noted that 377 of Indian Penal Code discriminated against certain identities and was used as instrument of harassment and physical abuse against hijras and transgender persons. Next slide, sir. We have seen that gender is a person's choice. Sex is a natural. It is by birth, whether you are a male or female. But after birth, only a person chooses whether he can be a man or woman. Uh, so, uh, um, but these rights are uh, provided under the constitution, but constitution says that guarantees rights to any person or I mean citizen but it is not expressly mentions about the transgenders. Through judicial interventions only, we can we are recognizing transgender people's right, and we are recognizing them as third gender. Now, the third gender is there is a column for filling third gender, but measures has been taken for providing welfare of transgender person, Transgender People Protection Act, and the rules are there. I conclude that a transgender person can be the first rejection is from his family. That is why they are wandering here and there as doing prostitution and begging. But welfare measures have made a change in their life. We can see that many transgender people are seeking other dignified jobs. They are doing some other jobs other than they are not going to the wrong way, immoral way. We can see many makeup artists or some other person, they are competing with others and they are finding jobs in judiciary, in police service, or in as an advocate. We can see them in many professions. Because of this recognition, judicial intervention and recognition of the government only, there is a slight change in their life. But the first important thing is that every family should consider every person is unique. So, family involvement. Uh, 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 Most of the parents are concerned about the society, what others are thinking about their family, if they recognize their children. So the attitude of the family members, we can make them aware by conducting awareness camps, putting programs of awareness programs in through media, social medias, or TVs, or anything like that. So the first thing is that the family's attitude should be changed in order to protect a transgender person. Yes, sir. Sir, previous slide, please. The previous slide. Ah. Excuse me, sir. I am not. I can't. Hello. Second, am I audible? Sir, am I
Yes,
audible?
ma'am.
Ah. Yes.
Parvati, please unmute yourself.
Yeah, sir. Can you hear me now?
Okay, thank you. Yes, ma'am.
Yeah.
Yes, ma'am.
Second thing is that the society's involvement. So one family's attitude change, automatically society's attitude also change towards the transgender person. Then legislative involvement. The legislature should make more laws. Government should make more rules for protecting transgender persons. Then ensuring implementation. Once the legislature is made any act for protection of transgenders, the government, the concerned authorities, concerned departments should ensure that those laws are properly implemented. That's all for today. Sir?
Thank you, ma'am,
Ah,
for your insightful session. And now the floor is open for discussions. If anyone have any queries, please feel free to ask.
any doubt, participants?
I think,
No, ma'am. All good. Thank you so much.
but ma'am, there are few questions we have received in our chat box.
Yes, sir.
Uh, First
First
question is,
question is,
ma'am,
ma'am,
can you
can you
enlighten us
enlighten
on
us
the
on the
existence of
existence of
Manu
Manu
and who is
and who
Manu?
is Manu?
Ma'am, can you hear me?
Yes, sir. Hello, sir.
Yes, ma'am.
Yes, ma'am. Ma'am,
There are
ma'am,
two
there are two
questions
questions
in
in
our
our
chat
chat
box,
box,
ma'am.
ma'am.
First
First
one
one
is,
is,
who
who
is
is
Manu?
Manu?
Yeah, sir. Manu and Manu Smriti. If there was no trace of Manu, it's my request to you to avoid quotating Manu and Manu Smriti. Okay, sir. Since I was concentrating on constitutional provisions, I am not much studied about Manu Smriti. Hello, sir.
Ah,
Next one is
Okay, ma'am. I
what is
think
SRS surgery is sexual reassignment surgery. Many people are still thinking that if a person who is transgender, he is dressing up like a male or female, but actually sexual reassignment surgery is providing if a man want to become a female, uh, top part and the down part surgery is happening. You can see many YouTube videos are there how these sexual reassignment surgeries are conducted, and many governments are providing financial assistance for conducting sexual reassignment surgery. For example, in Kerala government is providing assistance for financial assistance for sexual reassignment surgery.
thank you so much, ma'am.
Uh,
I guess everything is clear, ma'am. So, can we conclude our today's session?
yes.
So, thank you so much, ma'am, for delivering
Sir, one
such an
more question is
enlightening and
that
thoughtful.
one more question is that does gender pluralism and laws given for transgender people applicable to those transgender people belonging to different religion? Whether you are in a Hindu or Christian or Muslim, you are if you are a transgender, the gender pluralism applicable to every transgender person. Sir, you can wind up, sir.
Yes, sir, ma'am. I think one question are there. So, can we conclude?
Yes.
Okay, ma'am. Thank you so much, ma'am, for delivering such an enlightening and thoughtful session on gender pluralism. Your today's delivered thought has not only broadened our understanding of constitutional guarantee of equality, dignity, and freedom, but has also reminded us to gender justice is an evolving collective responsibility for all of us. Your today's enlightening also reaffirmed that the pluralism is not merely a constitutional ideal, it is a live reality we must constantly nurture through dialogue, policy, and practice. Ma'am, we are deeply grateful for the time and effort you dedicated to preparing and delivering such an engaging and comprehensive lecture. We are also extended our heartfelt thanks to our respected Vice Chancellor, faculty members, all participants, and everyone present here for their support and active participation. With this, we conclude our today's session. Thank you once again, ma'am, and we eagerly look forward to your continued engagement in the upcoming lecture of this series.
Thank
Thank you,
you.
ma'am,
Yeah,
once again.
sure, sir. Thank you so much, sir.